On divorce and legal separation, it should be mentioned that the Council adopted a regulation in 2003 concerning jurisdiction and the recognition and enforcement of judgments in matrimonial matters, the so-called Brussels IIa regulation. It applies to the dissolution of matrimonial ties between the spouses. It does not cover, however, matters such as the grounds for divorce, property consequences for the marriage, or any other ancillary matters. This important regulation defines the jurisdictional rules directly applicable in the Member States, indicating to which courts a spouse can go. The regulation indicates, for example, that the spouses have the possibility to institute proceedings in the jurisdiction of the Member States where the spouses were last habitual resident, insofar as one of them still resides there, or where the respondent is habitually resident. The judgment given by the court, let's say situated in UK, shall be recognized in any other member state without any special procedure being required. In particular, no special procedure shall be required for updating the civil status records of a member state on the basis of the judgment given relating to divorce, legal separation, or marriage annulment. The recognition of such judgments in any other member state is based on the fundamental principle of mutual trust between member states. Therefore, the grounds for non-recognition are reduced to a minimum required. Apart from Brussels IIa regulation, the Council adopted in 2010 a regulation defining rules on the law applicable to divorce and the legal separation, the so-called Rome III regulation. It must be said that from the outset, this regulation was adopted in the context of the first enhanced cooperation ever adopted at the level of the European Union. This means that this regulation only applies to 14 member states. The substantive scope and enacting terms of this regulation are consistent with the Brussels IIa regulation.